Good day, Crime Talk aficionados. That's right, it's Sunday, but we have a weekly recap of all the top stories from November 11th, all conveniently located in one particular location, right here. I hope you enjoy it. We'll see you next week. And remember, the Constitution matters.
Hi, lawyer.
That's right. Richard Allen, guilty. Turns out the jury believes he is the bridge guy. Now, for those who are not familiar with this, Richard Allen was accused of the murders of 14-year-old Abigail Abby Williams and 13-year-old Liberty Libby German, who disappeared back on 13th of February of 2017 while hiking along the Monon High Bridge there in Delphi, Indiana. Their bodies were discovered by the search team the following day in a wooded area, and the jury began their deliberations on Thursday afternoon of last week following closing arguments and continued until shortly after 3:30 p.m. They resumed Friday morning at 9 a.m. and deliberated until about 4 p.m., and they were unable to reach a verdict. On Saturday, they convened for several more hours, pushing the total deliberations ultimately to about 18 hours until they'd ultimately reached their decision. And yes, he was found, Richard Allen was found guilty on all counts, all four counts. He now faces 130 years. Sentencing is set for December 20th of 2024. Now, to a lot of people, this is a complete shock. And to other people, it is not. The jury has spoken. The jury has taken their time to look at the evidence that was presented to them. Now, I know a lot of people that are supporting Richard Allen are going to say, but they didn't even get to present their case. They did not. That will be an appeal issue. And ultimately, the appellate courts will decide if Richard Allen got a fair trial or if he didn't get a fair trial. And if he didn't get a fair trial, guess what? We'll get to do it again. And they'll be able to present their alternate suspect defenses. The defense wanted to present, but Judge Francis C. Gull kept the jury from hearing. So we're going to have to wait and see. But either way, we are talking now 7 years, and there's now justice for Abby Williams and Libby, all right, and Libby German. So after 7 years, we finally have justice for Abby Williams and Libby German. The prosecution proved their case. What do I say all the time here, ladies and gentlemen? It's always the defendant's own words that get them, okay? I was thinking Richard Allen had this case until we started getting word about all of the alleged confessions. Well, the jury now believes they're not alleged confessions. They're believing that they were confessions. The gun itself, the bullet found at the bodies and whether it was cycled through his gun could have dealt with that. They dealt with that, in my opinion. Would have been nicer if they said it wasn't a match, but they didn't. The defense own expert couldn't say it wasn't a match. He said he just didn't agree with the process in which the government experts conducted their evaluation. But when it comes to making statements about killing people, people don't necessarily do that. Even if you are in a state of psychosis, even if you believe you are basically having an emotional breakdown, it's still not good to go around confessing things you didn't necessarily do because there's always a chance that somebody's going to believe that's what you did, okay? You just don't go and do it. And I said all along, it's always the defendant's own words to get them. Now, we haven't heard from the jury yet, and we'll see if anybody actually from the jury talks to the press and the public. But the reality of it is my guess, this is a guess at this point because I haven't talked to any of the jurors, that it was those statements. People just don't talk about things like that and not expect people, when you say it enough times, to generally believe it. You weren't in this total state of psychosis the entire time, so to speak. Maybe a potential appellate issue, but like I said, Richard Allen, guilty on all counts. Next, never waive a jury. Well, the migrant accused of murdering the Georgia nursing student, Laken Riley, has waived his right to a jury trial, and now his fate will be determined by a judge. Now, Jose Ibarra's waiver and approval came during a hearing in Athens, Georgia, just one day before jury selection was due to start in this case. Now, Mr. Ibarra is 26 years old and came to the United States over the southern border, and he is accused of killing a 22-year-old woman back in February by hitting her over the head, asphyxiating her, and intending to sexually assault her. The defense team had requested that the fingerprints be thrown out, claiming that they were collected illegally by the police. Now, during the hearing, the district attorney stated that the defense had contacted her last week and said that they wanted a bench trial. Then, after the judge questioned Mr. Ibarra via translator, the judge said he found that Mr. Ibarra was making the decision knowingly and voluntarily to waive his right to have a jury trial. Now, his trial is scheduled to start on Friday, and prosecutors have already indicated they are not seeking the death penalty, and they will instead push for a life sentence without the possibility of parole. Now, in addition to the 10-count indictment to the connection of Laken Riley's murder, Mr. Ibarra is also facing another charge for allegedly peeping at a University of Georgia staff member on the same day as the slaying. Now, for those who don't recall, Miss Laken Riley's body was found on February 22nd, covered in dirt and mulch after a friend told police she had not returned from a morning run near the University of Georgia campus. Now, Mr. Ibarra had made his way from New York, where he was arrested in August of 2023 for riding a gas-powered moped with a 5-year-old on the back of it without a helmet. Now, after being cut loose from custody, Mr. Ibarra then allegedly fled to Georgia, where his brother Diego, who has ties to the gang Tren de Aragua, lives, according to police. Now, Ibarra has pled not guilty to the charges, including 1 malice murder, felony murder, kidnapping, aggravated assault, aggravated battery, hindering an emergency telephone call, tampering with evidence, and being a peeping Tom. Now, generally, I don't care how bad the facts are in your particular case, you don't waive a jury, right? Because the prosecution has to prove the case to 12 people beyond a reasonable doubt to each and every element of the offense. Now they only have to do it to one person, the judge, who knows all the facts, who's ruled the evidence wasn't collected illegally, and is obviously going to find him guilty. But going in front of a jury is it's a scary thing for a lot of people. To be looked at, to be judged, so to speak. A lot of people don't like it. We have lots of clients that don't want to go to trial, but they don't want to plead guilty either. So we have a little dilemma. Well, eventually somebody's going to have to decide, and well, it's either a judge or a jury. That's right. The judge who was set to oversee the Moscow, Idaho murder trial for Bryan Kohberger before he granted the change of venue and it got moved to Boise, well, he plans on retiring. So Judge John Judge of the Idaho's 2nd Judicial District there in Latah County signed a letter last month notifying the state of his intent to retire. So the judge submitted his retirement letter a month after he granted the change of venue sought by the Bryan Kohberger defense attorneys in the case involving the death of 4 Idaho students. The letter states, "After extensive contemplation, I have decided that it is time for me to retire." The judge wrote, "It has been a journey of hard work, challenges, life lessons, sacrifices, joy, satisfaction, and sometimes frustration and heartbreak." Now, the judge is going to turn 69 next month, and he said that he cherished his 40-year legal career, which included 24 years as a private attorney and 16 years as a judge. He has been in the current district court role for the past 6 years, which included about 15 months he spent handling the Bryan Kohberger case. Now, for those who don't know, Bryan Kohberger is accused of killing 4 University of Idaho students, Madison Mogan, Kaylee Gonsalves, Zaina Kernodle, and Etha Chapin, who were found dead at their home there on King Road there in Moscow, Idaho, 2 years ago today. The home has since been demolished, and yes, this is the 2nd anniversary of their murder today. Next on the docket, an update on the Daniel Penny trial. Hashtag free Daniel Penny. Now, a Marine veteran who served with Daniel Penny, the chokehold suspect, took the stand Thursday during his trial in the manslaughter charges as it regards to the death of Jordan Neely. Well, his former Marine Corps buddy, Joseph Cavalier, a former Marine Corps sergeant, said that he had given Penny martial arts instructions and explained a blood choke designed to knock out an aggressor in just a few seconds, with pressure to an artery, which he said is never held more than about 5 seconds in training. That's different from an air choke, which applies pressure to the aggressor's Adam's apple and can be held for minutes. Now, prosecutors showed a picture of the subway chokehold, and Cavalier said it looked like an attempted figure 4 blood choke. However, Cavalier said Penny's arm could be putting pressure on Neely's trachea instead. But on cross-examination by the defense attorneys of Mr. Penny, Mr. Cavalier said he agreed that someone could be placed in a chokehold for more than 13 seconds and not lose consciousness if the person performing the hold wasn't applying pressure. He also said that while Marines are told not to apply a chokehold for longer than 5 seconds in training, that doesn't apply to real-world scenarios. And it was asked, quote, is there any point Mr. Penny appears to be applying a blood choke fully to Mr. Neely to go unconscious? Question, quote, right? And then the attorneys showed the witness pictures and video images. And Mr. Cavalier responded, not from what I can see. When asked if there was any reason why the hold should be released completely before Penny was 100% convinced that Neely was no longer a threat, Mr. Cavalier said the decision would have been up to Mr. Penny's best judgment. If you release the hold too soon, there could be a struggle, Mr. Cavalier noted. Well, after the video played again, Cavalier said that at the start, Penny did not appear to be applying as much pressure as he was at the 1 minute 43 second mark when Neely started struggling. And then he relaxed his grip again. Under redirect examination from the prosecution, Mr. Cavalier backed off an earlier exchange in which he suggested Penny could have been holding a botched blood choke. So based off just the assumption that he was applying pressure, yeah, it could have been some kind of air choke, he said, adding that the Marines don't teach air chokes. Anyway, the training we taught while they were in the military was modified based upon the situation that they were in fact facing. The trial started a little late today because a juror was delayed, and the jury was shown a clip of a body cam video that had been played earlier but missed the sound due to some technical difficulties. In it, a witness told police about Mr. Neely's aggression and the death threats that he made to everybody on the train. Quote, he told like everyone that he had like a rough day and that he don't care what happens today. He don't care about going to jail, but that someone's dying today, the witness said, end quote. Another witness complained to the responding officers about their delayed responses. Everybody I was calling 911 and they took a long time to come. He tried to resist him while somebody came, but they took long. Dude got up and saw he was about to hurt somebody and he got up and restrained him. That witness added, referring to Mr. Penny, and he was trying to restrain him until the police arrived. So going into the 6th day of testimony, the prosecution has already called 31 people. I think it'd be fair to say not all of the testimony is going the way the prosecutors hoped it would. I think it's going quite well from what I've seen as it relates to Mr. Penny's defense. I seriously hope that he is found not guilty. Normally we reserve judgment. In this particular case, hashtag free Daniel Penny, all right? He was a good Samaritan. He shouldn't be prosecuted for some guy with mental health issues on the train threatening somebody. He took action that he thought was appropriate, as did apparently just about everybody on that train. And then to turn around and get prosecuted is absolutely ridiculous by that joke of a district attorney, Mr. Alvin Bragg. Anyway, that's how I feel about that case. First, the Laken Riley trial, the chilling 911 call that captured the Georgia nursing student Laken Riley's horrifying final moments was played in court today, leaving her mother in tears during the first day of the opening statements. Now, Laken Riley triggered the emergency function on her cell phone and called 911 while running on the University of Georgia campus around 9:11 in the morning on February 22nd of this year. Well, the prosecutors told the courtroom only a male voice was heard on the brief muffled audio that was played in court, and those in the courtroom listened to the operator repeating herself, saying, "Clark County 911, hello, Clark County 911, can anyone hear me?" The call was ended at 9:12, and the operator tried to call back but received no answer. Now, Riley's mother, Allison Phillips, was sobbing during the 911 call. The suspect, however, Jose Ibarra, sat stone-faced as the call was played in court. Now, in opening statements, the prosecutors detailed how Riley fought for her life for a staggering 18 minutes. Now, the state alleges that Ibarra was hunting for females on the day that he came across Laken Riley. Now, when Laken Riley refused to be raped, he bashed her head in with a rock is what the prosecutors say happened. The prosecutor stated, quote, "The evidence will show that Laken fought. She fought for her life and dignity, and in that fight, she caused this defendant to leave forensic evidence behind. She also marked her killer for the entire world to see." One of Riley's friends alerted police that she failed to return home from her run later that morning, and the nursing student's body was found in a wooded area near the running trail shortly after noon. Now, the coroner's office said initially that there was definitely evidence of foul play at the scene and that Miss Riley had been killed violently. But this trial is going to go super fast. Mr. Ibarra waived his right to a jury trial. It's a trial to the court, so you don't have to worry about all the formalities of a jury. I'm telling you, this thing ought to take about 3 days. I think we'll be done by Tuesday or Wednesday, and I would anticipate a guilty on all counts. We'll give him the presumption of innocence because that's what he's entitled to, but it's not looking good so far.